This recording is dedicated to the memory of Sean Stout. Sean was a client. For those who are familiar with the Spicy Burger case, he was the individual who was the subject of that case, the one who ate the burger and ended up getting very badly injured. I learned today that Sean passed away on July 31st of this year. So this is being done in your memory, Sean. We're wishing you the best. Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited for this after-action review, where we'll be sitting down with Megan Burns and Emily Dahm from Mirador Law. We'll be discussing their path to a successful verdict in Maria Guadalupe Jimenez and Esmeralda Gonzalez versus New Haven Unified School District. In the school incident, the defense made formal offers prior to trial of $115,000 to Maria Jimenez and $50,000 to Esmeralda Gomez. The jury's verdict was $9,573,616. Megan and Emily will tell us how they achieved this record verdict. Welcome to the show, Megan, Emily.
Thanks for having us.
I'm really looking forward to sitting down and getting a better sense as to how this case came together, what worked, what didn't work, and what have you. So before we do that, can you give us just a little bit of a sense of your firm, who you are in terms of your practice and how you found yourself doing this kind of work?
Well, thanks for having us, Miles. We really appreciate the invitation. Our firm is Mirador Law, and Mirador means a turret or a tower with an extensive view. And we recently renamed our law firm about a year ago, and it was very intentional because the way that we practice law, we believe we have strategic vision for cases, and that comes from our deep experience as trial lawyers. Both Emily and I started our legal career as public defenders, and we have between us well over probably 100 trials under our belt, a lot of them representing indigent clients facing charges, but also we've transitioned now to do civil trial work, and we really enjoy it. But that's what Mirador Law means. That's what we're about. We, I think, have a unique perspective because we're a women-owned, LGBTQI-owned law firm here in the Bay Area. And so I like to think that gives us a unique vision of how to look at trials.
For me, I don't know that I saw myself doing plaintiff's work in my future. I think I started out at big law, big and bigger. I was doing corporate finance in Hong Kong my first year out of law school. That did not lift my heart to the highest heights, and then found my way to litigation, and then found myself to the public defender's office in San Francisco and thought that was going to be my forever home. And then I hung out a shingle. And within a year, joined up with Megan, and here we are. And I have to say, even though I don't think I would have predicted plaintiff's work in my future, I'm sure awfully glad it found me. And it's been a real joy.
What I will share along these lines is, in an era where a lot of civil cases are being settled, it's nice to see people making the cross from criminal to civil with that trial experience.
We could go down a rabbit hole on that too. There are far too few criminal cases getting tried as well. And so I just think trial practice in and of itself is becoming perhaps a little too rare, and it is just as important as it always was.
Well, it may be a rabbit hole. If it won't take us off too far, for a minute or two, that would be interesting to hear your perspective on that.
Well, I mean, I think, what, it's been a big issue and so I still practice. Half of my practice is still criminal defense. And so, it has been a very big topic amongst the criminal defense bar for probably the last decade or more. Martin Sabelli, he's a federal practitioner and an excellent attorney, has really taken up the charge on this. But, there is a trial penalty. There's a trial tax for criminal defendants that, if you don't take the deal, the judge is going to give you worse after trial. There is some people would say some of the courts are kind of complicit in that, but you also have, I think, a pattern of overcharging, to essentially bid the defendants down, and the costs, the risks to go to trial are a lot, and it takes an incredibly brave person to take a criminal case to trial. You have to be incredibly resolute to stand up against the weight of the government, and when somebody tells you what your maximum exposure is on some of these very serious cases, it can be terrifying. Even though you may have the better case, you may be factually innocent even, or what the government is asking for in a settlement is in no way, shape, or form commensurate with your culpability. But, so it's really hard. It's really hard to get cases to trial.
I'm interested in the having the dual practice, and part of the reason I'm interested is that used to be a fairly not uncommon format where there were people who had both a thriving civil and criminal practice. It seems like it's gotten to be very rare. And when I've asked people about it, more in their comments is that it's really challenging to manage the criminal calendar in terms of the demands and also have a civil practice. And so I'm curious how you've been able to make that work.
Well, we're still figuring that out, I'll be frank. I mean, it is hard. It really is hard. You don't have the control over your calendar in criminal cases the way that you want. You can get a new case and your client's in custody and you got to be in court in an hour. Or, you say, gee, judge, that day doesn't work for me. And the judge says, well, sorry, we only hear these motions every third Tuesday under a blood moon. And this is the third Tuesday under the blood moon. And we will not be adjusting the court's calendar for you. And you have clients who have speedy trial, speedy preliminary hearing rights. And so that really constrains your ability to control the speed of your cases. So it can be challenging. And I think that's why it's challenging to do as a solo. I couldn't imagine it. And that's why I think one of the things that enables us to do it, it's that we have each other and we have the other lawyers at this firm and the professional staff at this firm to help us manage that. I think I couldn't imagine doing it just by myself.
And I'll just add to that, what Emily says is 100% correct. I echo everything she said about the fact that sentencing laws for criminal defendants have gotten higher and higher as the years have progressed. And so there is such a risk of going to trial in a criminal case that less people are willing to do that. And so the result of that is more innocent people taking deals that they shouldn't take because they don't want to face life in prison in front of 12 people they've never met in their life. I mean, that's really the kind of cases that we end up getting calls about. Those are the kind of stakes at issue for our clients. And I agree with you, Miles, that there used to be a lot more law firms that did both criminal defense and plaintiff personal injury. And I'm not aware of another law firm in the Bay Area that actually does those two practice areas like we do here at this firm today. And I think from my own perspective, part of that has to do with the complexity of trial work that has happened over time. It used to be, for example, on a criminal case, you could have a homicide, and that case might take a week to go to trial, and there would be a lot less discovery. The same kind of issues that, we face in the civil cases with just massive amounts of discovery, a lot of audio and visual discovery, body camera footage in the right kind of case, these kind of things. It's just a much more complex practice to do trial work, whether it's criminal or it's civil. And so it's really hard, I think, to manage that. That's why, we try to have more of a boutique practice where we're not taking every single criminal case. We're being much more selective about the people that we can help on the criminal side of the practice. And we're kind of doing the same thing on the plaintiff personal injury side. Not every case is going to go to trial, but we as dyed-in-the-wool trial lawyers, we evaluate every single case, whether it's on the criminal side or the plaintiff personal injury side, as if it could be a trial case. And I don't know another way to do it. That's just the way my mind works. And I know Emily is the same.
On the civil side, have you found that there are types of cases? And part of the reason I'm asking this is we're here to talk about a particular case that's what I would euphemistically describe as a school site incident. Are there types of cases that you have found to be more in your wheelhouse, or are you an all comers? I'm a trial lawyer. I try it because I'm good kind of firm.
Maybe I can take the first bite at that question. I think that because we do another practice area, we are very conscious of trying to stay in our lane. So there are certain sorts of plaintiff personal injury cases we don't typically take. Products liability, medical malpractice, some other kind of specialized areas. We are going to refer those out to friends and colleagues that we know are really good at what they do. But that's not what we do. We have more of a global kind of run-of-the-mill PI practice is what I would say. But because we are real trial lawyers, we do like a challenge. And so there's always an exception to the rule. I am about to put a case in litigation right now that's a medical malpractice case because it's the right thing to do for this client. And I know that I have the team in place in that case to really be successful. So, I think it just depends. We're always willing to look at a case and we're always willing to take on a challenge in the right set of facts. I think that's what I love about plaintiff personal injury work is I feel like I'm always learning every single day. And it's not to say that I don't feel that way being a criminal defense practitioner, although I'm not handling any criminal cases any longer. But I think it is the field is so much diverse. There's so many different sorts of legal issues that come up. It's just the scope is bigger. And so I like the challenge, and I think Emily does as well.
Yeah, I think that's all dead true.
Could I ask one of you to perhaps set the stage? Our audience doesn't know anything about this incident, and before we dive into how you built the case and the trial itself, would one of you like to, or both of you like to help give us a little bit of an understanding of what led to this incident?
So the case of Maria and Esmeralda was a case that came to our firm through a referral through my network. I do happen to speak Spanish. And so to this day, Maria and Esmeralda don't know who gave them my name, but somehow they got my name through the Latino community. And they reached out to me about this incident. And basically what happened was about a series of bullying events that had taken place at James Logan High School for approximately a year. At the time that I met Esmeralda and her mom, Maria, Esmeralda had been a sophomore student at James Logan, and she had been bullied by another female student. The school knew all about it. They had never notified Esmeralda's parents as to what was going on. Eventually, the bullying escalated to the point where Esmeralda was incredibly worried for her own well-being and finally self-disclosed to her parents. And on that day, Maria, Esmeralda, and some other family members went to the school to try to meet with the principal to really get intervention into what had been occurring. And as they drove into the parking lot at James Logan High School, the bully and a number of her friends, along with the school security guard that was a family member, at least a family-connected person to the bully, not a blood relative per se, met them in the parking lot, and immediately when they got out of the car, started attacking them. Esmeralda was protected by her stepfather, who threw his body over hers while multiple other students were trying to kick and punch her. When Maria tried to intervene, she was pulled over away from the group and was primarily attacked by one person and beaten unconscious. She really had some serious facial injuries that later required surgery. And you can imagine from an attack like that, there was a very real and visceral experience that they both had with post-traumatic stress disorder. And I can go on about the damages, but that was essentially what the case was about, was a bullying incident.
Megan's set the table quite nicely for the facts, but there's one that's missing, and that was during the time that this beatdown was taking place, in the school parking lot, within shouting distance of the principal's office. Maria had just had a baby 3 months prior, and that baby was still strapped into the car seat, still strapped into the car. So while she is watching her eldest daughter and her husband being attacked by this bully and her friends, And then while she herself is being attacked, she has absolutely no idea whether that baby is safe or not, what's happening to it, anything. So that's just that other fact that just sort of takes how terrifying this was, I think, and makes it really real. If you have even an ounce of compassion in you, you'll know how scary that was.
I'm obviously a plaintiff's lawyer, but even being outside of being a plaintiff's lawyer, I would say at the outset, it sounds awful. What kind of a defense could justify the relatively low numbers that the defense team was offering in this case?
Well, it didn't.
Okay.
I think that's exactly the story of this verdict, is that there wasn't a defense that could justify the low numbers that they were offering. And it really kind of boiled down to a lot of denial on their part. We never know. We never knew. How could we know? They really fixated on the fact that Esmeralda had not affirmatively made a report of bullying, which I think does not track the facts particularly well. Because what we do know is that there was an incident early in the year prior in which it was witnessed that she was getting bullied by this girl. And of course, what was the whole beef about? A boy, right? The boy that the bully liked ended up having an interest in Esmeralda. And so therefore Esmeralda became, a lightning rod for this girl. But they claimed, despite all of the facts, that they had no knowledge, the district had no knowledge of this. And then their sort of secondary argument was, well, boy, oh boy, this just sort of popped off so suddenly. This was also just emergent in it, and it just happened all of a sudden. And therefore, how could we have known? How could we have stopped it? There's nothing we could have done. And hey, even your clients said that this was a surprise to them, that this happened. So if it was a surprise to them, it certainly was a surprise to us.
I 100% agree with Emily. And the case law in California from the Supreme Court has been very clear for many years now about that dual duty to protect and control students and other people on campus for whom the school has a duty to protect. The district had just an incredibly myopic view as to what the law required them to do. And they never accepted kind of the basic Hornbook laws to what their duties were on campus. And I think that fundamentally was part of it. I think that they also tried to say that this incident was such a surprise. It just happened all of a sudden. How could they protect? How could they control? They completely ignored the fact that there was a school employee that, from our perspective, was actually part of the incident. And they didn't factor in at all how that would factor into how the jury would see this case. And I just think they totally misjudged it. One thing we were talking about a little bit before, Miles, about what kind of law we do here at this firm. I think one of the ironies of this case is that Emily and I had never done a bullying case before in our career. Ever, full stop. This was the first bullying case we had ever handled. I'll say something out of both sides of my mouth, which is we stay in our lane because we do two separate practice areas. But I'm going to speak out of the other side of my mouth to say when I met Esmeralda and I met Maria, I said, I have to help these people. And I don't know all the laws about bullying and what schools' responsibility are, but I'm going to learn them. And that's what we did with this case. And one of the things that we very smartly did was associate in another attorney on this case, because I've got to give Charles Delario props. He was the 2019 California Appellate Lawyer of the Year, and he has been instrumental in crafting the law on bullying and schools' duty to both control and protect students and others on campus. And so we brought Chuck in as part of our team from the very beginning when we filed the complaint. And he was there with us throughout the litigation process, including, some very wise decisions he helped us form with regard to eliminate motions and which ones we were conceding and which ones we were going to fight. So that's always really important. If you're a good trial lawyer and you don't know the law in an area, bring somebody else in that's a specialist in that particular practice area to really help you. And Emily and I would not be sitting here today without Chuck's assistance with this case.
One of the takeaways I'm hearing from you is if it's outside your wheelhouse, bring in a subject matter expert, either as a consultant or as a co-counsel in some fashion to help make sure that you're able to deliver and not make missteps.
1000%. It's like, how many times do we tell clients, if you represent yourself, you're a fool for a client, right? Like, I think the same is true of attorneys. When you're at small firms and you are looking at a case and you can say, look, this is a horrible tragedy. I know that there's a case here, but it's not a particular area of law that you've ever handled before. Make sure that you're talking to the right people. I think that's one of the things that Emily and I are really good about. We have no ego in this. Like, we're more than happy to say, you know what? I don't know about this area of the law, or I've never dealt with this aspect of accident reconstruction or whatever it might be. And we phone a friend. We're always phoning our colleagues, whether it's experienced criminal defense practitioners or our fellow trial lawyers and plaintiff personal injury work or appellate specialists. We want to understand who knows this area of law better than anybody else, and we want to pick that person's brain. And we constantly do that in our practice.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I want to put a pin in the motion limine strategy and what to go forward with and what to concede, partly because I'm a chronological thinker. But that sounds like a very important piece in terms of maintaining the verdict post-trial. So we'll get there. I did have a question about the security officer and whether that individual was in course and scope at the time that all this went down, or
Yes.
was that contested?
No, I don't think it was actually contested. I mean, he was a very interesting character and an empty seat at trial. We can talk about the reasons for that later. But so this is a security guard who had a non-blood familial relationship with the bully. He was if you know the term play uncle, he was a play uncle of hers. She called him uncle. They're very close with the family. And so he had, just on the day of the incident, had essentially allowed the bully and her friends to leave a classroom, go out through a gate that they weren't supposed to be going out because school's in session, go into the parking lot area in front of the principal's office, which is an off-limits area when school is in session. One of the bully's friends who helped with the beat down was a non-student, and somebody that he likely also knew, and so should have immediately recognized that this person shouldn't have been on campus in the first place. And then he took this whole group out to the parking lot where he could see and they could see, and he knew that they had a beef with Esmeralda, and literally, almost like a master of ceremonies in my mind, brought them to the parking lot, almost like in corner number 2, we've got, and he just brings these feuding group together and watches it. He just watches it. He doesn't do anything to stop this fight. He doesn't do anything to intervene. He doesn't, call for the cavalry. And so he's kind of there like a potted plant, abandoning his duties, but still very much in the course and scope.
That seems like a bad fact.
It is a very bad fact for them.
I might just also add that not only was the fact that he was in this course and scope of his employment not contested, but the trial lawyer for the defense actually stipulated to that fact at the trial. And so that is also a very important aspect of how this case is being considered on appeal.
When you say the defense lawyers stipulated to that fact. How is that factoring into the appellate side of things?
Well, because he was an active participant, there's a difference from an appellate standard as to whether you failed to act to protect and control, or whether there was an employee of the school that was an active participant. There's actually some different case law on that. And so because they stipulated that he was in the course and scope of his duties, and because the appellate court considers all the facts in the deference to the verdict, then our whole theory of the case not only was that the school was negligent, but that he actually was an active participant in this case because he violated all these different school rules and actually bringing the bully and her friends directly to where Maria and Esmeralda were at. And we didn't believe that there was an accident. Whatever his motivation was, which we never were able to know because we weren't able to depose him in the process, it made no rational sense to us as trial lawyers that he wasn't actually a part of this. And that is the facts that the court on appeal is considering, is a stipulation from opposing counsel that he's in the course and scope, and his direct involvement, not just the failure to act, which is just different.
Do you have an understanding as to why the lawyer stipulated?
No, I don't really understand why she made that particular choice to stipulate as to him being in the course and scope. I think ultimately, Emily and I have tried a couple cases together, and whenever Emily and I actually get to try cases together, it's like the best trial experience I've ever had in my life. But we've had a couple cases where Emily's described them as the Rorschach test. Like, you see the case one way and the opposing counsel sees something totally different. And I just think that that's what this case was.
Megan mentioned the term myopic, and I think that is so dead on in defense counsel's view of this, that she really just throughout the pretrial proceedings, but and particularly at trial, really tried to shrink the universe of what this case was about to just those seconds, minutes of the attack itself, and just really, really wanted to ignore, deny everything that had been leading up to it in the year prior. And so, I remember I did the liability portion of the closing argument, and I remember telling the jury, this is a choose your own adventure of liability. I mean, whatever door you go down, we are going to end up at the same place, which is that the district is liable. And as much as they want to just, have pinhole vision and just look at this at just that moment, we can do that. We can look at it as just that moment. But that moment's not a particularly good one for the district. It's not a get out of jail free card because, again, they have a district employee who is participating in this, who is enabling this, who is violating about 6 different policies and rules that are designed specifically to keep people safe on campus and to avoid incidents exactly like this. But you don't have to be so narrow. You don't have to close your eyes to what has been happening for the year prior, which is that this student has been bullying, harassing, terrorizing Esmeralda for the better part of a year. And there have been flashpoints at which the district was well aware of it, whether it's teachers hearing the screaming and yelling and passing, just days before this, the bully is screaming out to her across essentially the open air quad area over the lunch period and shoving her. She's having to be taken away from her during lunch hours. And I think the district lawyer lost a lot of credibility during the trial by denying what we could all see in front of us. There were these notes from, I think it was the November incident. It was one of the lunchroom incidents where the bully had been, getting in Esmeralda's face, making quite a big scene of it. And school security guards had to pull her away. And their teachers intervened. And there was a note about how the bully had anger management issues and they'd recommended counseling, and she was not willing to engage in it. But they misgendered her in the notes. They called it they referred to him, the bully, as him. And lawyer was sort of fixated on like, oh, yeah, it said of him. It certainly couldn't be this incident. This must be some totally unrelated incident, except for, you have our client testifying about it. Our client's friend who witnessed is testifying about it. The whole context of everything that's in that note is clearly about the dispute between these two girls. And you want to hang your hat on an errant pronoun? I mean, this is like, sometimes you get in our public defender days, I may have a client who said, well, they can't prove that was me on the video. And I'm like, no, but you are wearing hot pink pants. Like, that's fine. But, it's up to 12 people and 12 people got to buy that story. And so I think like that was kind of the approach, was just like, again, I'm going to just fixate on these little tiny facts that are not really actually helpful and losing the bigger picture. And I think she just lost so much. I mean, that's my opinion. I think that when you do that as a trial lawyer, you do that at your peril, and your credibility with that jury is sacrosanct. And the minute you sacrifice that, you sacrifice your client's chance of a good outcome. And I think your own good reputation.
Taking it beyond just your opinion, did you have an opportunity to talk to any of the jurors post to see what their feedback was on things like that?
We had a great jury, really, really nice people. We can talk about voir dire if you want and our approach to that. But I would just say after the trial, our impression of who we thought we had picked for that trial was totally borne out when they stayed and talked to us. And these were good, earnest people that actually wanted to do right by the school district. They really wanted to, in fact, told us directly, they were really looking for the district to give them some evidence to help them out, because nobody wants to, and we don't want to get a big verdict against a school district unless they really deserve it. I mean, you can't do these cases without a recognition that, when you sue a school district, maybe there's not more resources for teachers or, staff or equipment that they need for the school because it's going into a lawsuit. And so the jurors were really open-minded, I think, when they started the trial, of listening to both sides. And they were really looking for the school district to explain to them how something like this could have happened, and they were not negligent, and they just were never able to present that kind of information. And that's what the juries told us, that they were really, if there had been different facts, if there had been better facts for the district, I think the same group of 12 people would have been perfectly happy to find against our clients, but those weren't the facts of this case.
The jurors were great. They were really great. But I think too, had the district shown kind of some empathy towards our clients, and my perspective was that moment never came, and I think that was such a poor choice, because we could see through the trial, and I sat closest to the jury in kind of our layout in this courtroom, and I could see. I mean, hell, in Megan's opening, there were jurors starting to cry during opening statements, and so they had a lot of, the jurors had a lot of empathy for our clients. That said, they also had a lot of empathy for a public school district, and that was a huge issue. We can, if you want to talk about voir dire, and I can go into it more, but I did the voir dire, and that was the number one issue in voir dire was, are you going to be able to award full and fair damages if you know this is coming out of a public school district's pocket? And there were people who, passed that questioning, but, still had those very valid concerns on that jury pool and are in the 12. And, I think had somebody given them a bone, they would have taken it, and that number might have been very different.
I do want to go there. And I think we should go there now since it's come up a couple of times. I want to take one diversion before we get there, which is coverage and collectability. I don't do a lot of these types of cases. So a question for you on that side is this district money? Is it self-insured retention? Is there a policy in place? What are the deciders behind the scenes? Because that's a big number for a district.
So school districts, like most public entities, obviously they can't have traditional insurance in the normal sense of the word, but they have these pooling organizations that essentially function like insurance policies. And that's what the issue is here. I've done 2 different public entity trials in the last 12 months, both with successful verdicts for clients. And in both cases, the public entity had participation in a pooling agency, and essentially it acts just like insurance where they have some form of deductible. Unlike insurance companies where it's a for-profit, the whole purpose of a pooling agency is to spread the risk amongst many different public entities so that there's not some sort of verdict that then bankrupts a school district or bankrupts some other form of municipality. So it's really, at this point, it's us negotiating with the pooling agency because the school district has met their deductible already. And so it's really their decision whether or not to can persist with the appeal or not.
I was going to ask this question at a certain point, now seems appropriate. Was this the first verdict that you had in terms of a public entity?
Yeah.
Yes.
So do you think that the fact that you had not had a background in these types of cases factored at all into the underestimating you and approach to the case from the defense side?
Probably, and probably us underestimating how hard this case was going to be. I think that probably flows both ways, right? Maybe we didn't really know what we were getting into, and thank goodness we didn't. But yeah, I mean, I certainly nobody knew us then, and maybe even knows us now for being, those lawyers who take on those public entities. So I'm sure, and Megan, you can speak to it because you were in the trenches pre-trial. I came in at trial, so she saw firsthand how our buddies on the other side of the table were approaching us.
Let me just say that I'm going to use another public defender term, Miles, if that's okay.
Please.
A lot of our clients back in the day that we would be meeting with late at night, sometimes, many times on the weekend, charged with very serious cases in the county jail. A common phrase they might use is Google my charges. You want to know something about me? Google my charges. And that basically means, like, look at what I've done in the past. You better watch out. That's kind of what that means.
Okay.
And so I feel like, yes, before this particular trial, if someone Googled Emily and I's charges, they wouldn't necessarily be as concerned. Maybe if they had looked more carefully at how many trials we had actually tried, maybe that would have given them more concern. But I'm sure, going up against an opponent that you don't see, a bunch of huge plaintiff personal injury verdicts in their history, that you think you can underestimate an attorney. And anyway, so I think that could have factored in. I don't think that's why this case went to trial. I just really will go back to the fact that I think this case was just the Rorschach test. They saw the facts of this case and they thought, no majority of a 12-person jury is going to find this school district liable on these facts. And we just didn't see how they possibly couldn't find them liable. And those are exactly the cases that go to trial when the two sides are oceans apart. And we were always oceans apart, right up through the verdict.
You've referenced a couple points that the security guard, you were unable to depose the security guard, and that there was an empty chair. And I'm sure listeners are wondering a little bit, that's an interesting piece. What's going on there?
With regard to the security guard, of course, we noticed his deposition. Originally in the litigation, he had been separately represented by a different firm, clearly because the, lawyers representing the district itself probably saw the possibility of a conflict of interest based on the facts of the case. And when we noticed his deposition, we became aware for the first time that he had some medical complications that did not allow him to basically provide a deposition. And so there was, through a lot of the litigation, it was unclear whether he was going to get well, whether or not we were ever going to have a deposition of him. And he had a medical condition that he never improved enough to be able to participate in the litigation. So
Okay.
we were never able to depose him. There was some funny business during trial where the defense attorney tried to get the court to introduce some audio recordings from body camera footage of statements he'd made to law enforcement and suggested that there was hearsay exceptions for those statements but they were unreliable. And that's what the trial judge ruled, is that they were unreliable. So the jury never heard anything from the security guard. And again, just looking at this from all sides, that might have been something that, the defense might have wanted to reconsider in terms of taking the case to trial, is the fact that they were not going to have what really should have been their star witness testify on their behalf.
Did the jury hear about the medical piece, or did they just hear that this person was unavailable?
Just that they were unavailable was the only information that they heard.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.